John, welcome to Constituting America's Constitutional Chats. We appreciate so much all you do with Constituting America. And we'd love for you to begin by just telling us a little bit about the history of the Supreme Court and the history of its size.
All right, so we're going to discuss a little bit about how many Supreme Court justices there are and where that comes from, and proposals, I guess, to change it. But there have been, over the course of our history, 5 to 10 Supreme Court justices at any time. And that 10's a little iffy because they had that briefly and then pulled it back to 9. But at the beginning of the in the first Judiciary Act, there was 5, or very quickly 6. And the reason this gets a little interesting is because when the Federalist Party had held the presidency for the first 3 presidencies. Washington, it was really no party, but he was a Federalist type guy, and then Adams, and then Jefferson. And what happened there was that a justice left the bench. I think he died. They tended to die in those days. But sometimes they left because it wasn't a great job. They had much better jobs back home because for a long time they didn't do anything that was seen as important until John Marshall got there, really. But anyway, so the Federalists still held the Congress, and Adams was president, and so they decided to lower the number of Supreme Court justices so Jefferson wouldn't get an appointment when he won in 1800. And so there in the early republic, there was a lot of fights over the size. And this flared up now and again. I won't say often, but now and again, it flared up until when Andrew Johnson, he got in a fight with Congress, including an impeachment fight, and they decided right there and then they were only going to have 9. I think there was going to be more justices, and they didn't want Johnson to get an appointment, so they fixed it at 9. And they fixed it in about 1868. And since 1868, we've had 9 justices by statute, because the Constitution, if you look at Article 3, it doesn't say how many Supreme Court justices there are. It just says there shall be a Supreme Court, and there's a Chief Justice. That's all it says. And so the Judiciary Act of 1789, which was the first Judiciary Act, fixed the number of Supreme Court justices, created the first federal district courts, the first appellate courts. Nowadays, there's 11, well, there's the federal circuit as well, but there's 11 numbered courts of appeals, let's put it that way, to make it simple. And as the country expanded, they expanded the number of courts of appeals, but they never added the Supreme Court justices for each court of appeals, as was the way it was in our early republic. When there was, let's say, 5 court of appeals, there were 5 justices, 6 court of appeals, 6 justices, and it sort of marched with the expansion of the appellate courts. But for instance, in my lifetime, in the 80s, they split the South. The South used to be just the 5th Circuit by and large, a little bit of the 4th Circuit for Virginia and Maryland, but the 5th was split into the 11th and the 6th and the 5th, I think. I'm forgetting exactly how it happened, but I still see cases where it says the 11th Circuit takes the 5th Circuit's precedence from the old days. So, but we didn't get a new Supreme Court justice when that happened in the 80s. So I would say this about court expansion and court numbers. It was very contentious for a time in the early republic, depending on the party switches and especially the fights between the Federalists and the Republicans in the early days of the 1800s. Things kind of died down a little bit until the Civil War on the numbers issue, until Johnson got in a big fight with Congress, and so they fixed the number at 9, never changed, and there was a period of just quiescence, I'd say. I mean, just it was quieted down until the Supreme Court resisted the New Deal as too large an expansion, is not in accord with the separation of powers and a lot of other things, non-delegation, lots of constitutional analysis that the New Dealers didn't like. So they proposed for every old judge we had, every guy who reached 70, they'd appoint another guy to help him out because he's too old, right? So really that was just so that Roosevelt would be able to get 4 more justices, because a lot of them were old. They were called the 4 old men. So that was rejected by the Congress overwhelmingly. It split the Democratic Party because there was a huge revolt about it would give the president too much power. And just to preface and to end my comments on this particular issue, it's interesting that FDR solved his problem by staying in office long enough to appoint just about all the justices. He appointed 8 of the 9. So this hurry up, we got to do this now stuff was really proved by events not to matter, because the Democratic Party held the presidency from 1932 till 1952. Those are my introductory remarks.
Well, thank you. And that's a great history and overview of the size of the Supreme Court and how it's changed over the years and where we stand now. And I think I'm just going to go ahead and toss it to Tova for the first question.
Well, great. Thank you so much. That was a great overview. I really learned a lot. And I just had a few questions. So first of all, I'm really interested in sort of international relations and looking at things from an international perspective. So I was wondering if you had any knowledge about how other countries determine the size of their court. Is it unique that America sort of leaves that question open, or, and other countries have very fixed amounts of seats? Do you have any knowledge of that?
Well, I do have a little bit. It's usually statutory. I don't think most of the European, and I mainly know Europe. I can't really tell you anywhere other than that. But there's another little wrinkle here in that most of these places don't let the Supreme Courts do as much as our courts do. I'll give you an example. Britain has no written constitution. So they just recently got a Supreme Court. There used to be a high bench, and it was made up of legal scholars in the House of Lords. And recently they had some reforms and they made a Supreme Court. But I have to be pretty clear here. They can't really strike down statutes as unconstitutional because they don't have a written constitution and Parliament rules there. So in I think it was 82, for instance, Canada had a high bench, and they have the high bench that they have, and I believe that's fixed by statute as well. It's not they don't have a constitution. They have a charter. Queen Elizabeth sent them a charter and said, "Here you go. You have rights now." And so their charter, their Supreme Court can interpret the charter, and their Supreme Court, sometimes it goes around on the internet. You can look it up, but their Supreme Court doesn't wear black. It wears red robes. They all look like Santa Claus. And so they do strike down certain laws as inconsistent with the charter. And I think they're a fixed number by statute. I don't know the rest of Europe, and I don't know how Japan does it. But by and large, in a lot of these countries, Parliament can overrule the supreme rules a little easier. And the EU, actually, one of the reasons Brexit happened was because the Supreme Court of the EU, I'll call it, it's not what it's called, but it had control over a lot, particularly economic rules and social rules, and the British wanted out of that, and they do strike down laws as well, and that's fixed by the European Union.
Wow,
but again, I think outside maybe Israel, you don't have a Supreme Court that wields as much power as ours does. I'd be hard pressed to think of. You never see the French High Tribunal striking down something big in France, for instance. It's just not a thing. The Parliament would immediately take care of that problem. So you're not, in Canada, you do see it a little bit, and certain other places, but I think that it's sort of a unique, the strength of the Supreme Court is a unique aspect of our system.
Wow, thank you. I never really thought about it like that. It's really fascinating. And then just to go back to what you were mentioning earlier, could you describe the difference between a constitution and a charter?
Yes, okay, so this had to do with Commonwealth countries. So how they all got created. The United States is one of the most unusual countries in that it has a birthday that everyone knows. 1776, Declaration of Independence formed to declare it's independent from its previous the previous country. Now, I will say this: I have left out India, which also has a birthday, which was 75 years ago yesterday, and they also have a Supreme Court. But they are similar in about how they formed, not by war, but they came from the same old country, and they set up their constitution amongst themselves pretty much with sort of, there was like an overlap where the British ruled and set up the governing statutes that they then took care of themselves, but they have a birthday as well, and they have a Supreme Court like we do. But again, it's not as powerful, but it does strike down, it does make very important rulings. So charters are, there used to be, well, we used to have them. The Royal Charter set up Georgia, it set up Virginia, it set up Massachusetts, pretty much, except they then had, they did have the compact about how they'd run under the charter. But basically the king said, I'm sovereign, but you guys get to do this stuff. It's in a piece of paper. And this stuff that's in that piece of paper, the courts rule upon. Now, in reality, that's the theory. In reality, they vote on it like we do now. I mean, they amend the charter for interior Canada. They don't go back to the Queen. I mean, I guess they do. She has to affirm it, but she never says no. So whatever they affirm, that's what's in the charter.
So would you say it's the difference between the leaders giving certain rights to the people versus the people giving rights to the leader, to the government?
Yeah, I would, except for this. It's highly theoretical that the Queen gives anyone rights in the British Commonwealth. I suppose it's conceptually different, but it's not like the Canadians are worried that their taxes are going to be created by Queen Elizabeth II or anything they do. So it is operationally democratic and kind of in our form, but they do not have strict separation of powers, for instance. The real argument between us and Commonwealth, British, other Anglo-American, Anglo heritage countries, and I would also say to some extent the Germans and other federal, and the French a little bit, is this separation of powers idea. And I think the most powerful criticism of the separation of powers I have ever read is not in some administrative law book or anything like this. Walter Bagshot wrote the Constitution of England, which is, if you ever see the TV show The Crown, so it's on, you can see The Crown, but it's all about Queen Elizabeth's time in office. And she reads this book, and it's written like 1860, and he revised it into the 1920s. And he writes about why they have a queen and what's the, or a sovereign, why do they have a sovereign, what's the sovereign do, what's Parliament do, what's House of Lords do, and he splits it in those three, right? It's not judicial, executive, and legislative. It's basically the two houses of Parliament and the Queen, and he explains it all. And he's writing just after our Civil War, and he says that the separation of powers was a disaster in the Civil War, that it was very hard to execute the Civil War with the separation of powers until Lincoln won another election later on, got Congresses to come in on his side, which was kind of interesting. I've never really read, as an American, a criticism of the separation of powers from another free country's perspective, let's put it that way.
Oh, thank you. This was a great discussion. And then I just had a few more questions if we have time. So I know it's a contentious question now, whether to expand the Supreme Court, but let's say the president did decide to expand the Supreme Court. What would be the actual mechanisms to make that happen?
So he can't decide to expand the Supreme Court. He can appoint Supreme Court justices all the day long, and none of them are going to get in there. And the law actually says there are 9 right now. It's in the Judiciary Act. So you have to expand the number. And they've done it. As I said, they've done it many times. They go back and forth. Sometimes they do a rush job, and so that the president doesn't get an appointment, they say, "Oh no, you're not going to have 6, you'll have 5 because we don't want Jefferson, or we'll have 9, not 10 because we don't want Johnson to get any appointments." So, you know, when there's a powerful majority, as there was after the Civil War for Republicans or after 1932 for the Democrats, theoretically you can do it, but it's not likely now. But you can change the number statutorily. You don't need a constitutional amendment. This is not like, you know, what's another one that's proposed recently is changing, I can't even do that one. I'm just trying to think, like some things, oh, I know what it is, like the electoral college vote. It's very similar. We used to change the number of Congress members. Senators, every state gets 2. That's constitutional, can't change it. But Congress members used to represent smaller districts. So if you want the electoral college count to be closer to the popular count, you raise the number of congressmen in every state. The popular states will get more congressmen. Their electoral vote count goes up 1 for 1 for each congressman. There is no constitutional amendment needed for that. Until 1912, 1911, we expanded the size of Congress whenever we did a new census, and then they just stopped doing it for various reasons. They didn't like all those folks coming in from Eastern and Southern Europe, and so they just stopped doing new. Your congressional representation got larger and larger till now it's all like 700,000 or something. It used to be 30,000 in a congressional district. So that is a statutory way to get rid of that perceived problem of the electoral college not matching the popular vote. But on the Supreme Court, to change, you can change the number statutorily. You don't need a constitutional amendment. You do need a constitutional amendment, though, to change lifetime appointment.
Interesting. Yeah, and then I guess my other question is, you know, why did the founding fathers leave this question open about how many justices to have? I mean, it just seems like there's, you know, there was so much contentious debate over other issues like, you know, bicameral versus unicameral legislature, powers of the presidency, et cetera. So it's just interesting to me that the founding fathers would leave this open. Was it just something that they didn't really think about, or was it intentionally, we want to leave this open for people to decide?
I think, having read the Federalist Papers a lot of times and also seeing the history, it's my belief that they didn't put it in there because they didn't know how big the country was going to be. And they did put in, just like they didn't put in the number of congressmen, except each district shall be represented. You know, they did it by percentages. 2 senators, they knew they wanted 2 senators per state. And there was a big fight over this, and they knew how many they wanted congressmen done by population, but they didn't fix the number of congressmen. They fixed the number of senators, 2 per state, but they didn't fix the total number of senators. However many states you get. So they didn't think, they thought the proportion and the role each of the branches would play was more important. But the number of people on the Supreme Court, I think the main thing you need in a Supreme Court, if it's going to be a tribunal, is an odd number of justices. Okay, that is the most important thing, because you can't have them tying. So you need an odd number. I think that's the most important rule of how many judges you have.
Right. Well, thank you so much for answering all my questions. I think I'll give Lindsey a chance to ask some now, but thank you so much for being on.
Welcome.
Absolutely. Thank you so much for all of your great insights into this. I know I've definitely learned a lot because this is something that I've been curious about. But I had a few questions for you. So just looking over Article 3, I was probably most surprised by how brief it seemed to be. So my question was, why was there no mention of a specific number of Supreme Court justices within Article 3? Did our founders intend for this number to fluctuate?
I don't think they cared. I don't know if they intended it, but I don't think they cared. They didn't see it as destructive of liberty, the number of justices. In fact, there's a statement in the Federalist Papers that the judiciary is the least dangerous branch. And that has been taken up by legal writers many times. Doesn't have the power of the purse. It can't tax you, can't send soldiers after you, can't send police after you. So, and in order for it to have any power, you have to bring a case to it. If it doesn't get a case, it can't do anything. Also, they put in a lot of protections against the Supreme Court. There's what we call jurisdiction stripping, which is another thing that's been talked about, which is Congress can say that the court doesn't have jurisdiction over X, Y, or Z. Rarely does it, but when it does do it, they don't have jurisdiction. We saw this in certain of the immigration cases this term, where an immigrant had brought I don't want to say illegal, because I think it was an asylum. It was an asylum request, so it wasn't illegal. It was an asylum request, and the determination was made by the executive. And I could be getting the facts wrong. It was either illegal or an asylum. I forget what it was, but the main crux of it was the executive had made this decision about whether the asylum seeker or the immigrant could come in legally, and they'd made a mistake. They'd made a mistake on the underlying facts, but the Supreme Court says we have no jurisdiction. Congress stripped us of jurisdiction in this area. And Gorsuch had a huge dissent with a number of the other judges. It was, I think it was 6-3. Yeah, I think it was 6-3. But they said, look, it's out of our hands. Congress said we don't have jurisdiction. We don't have jurisdiction. So the founders thought that the protections from a court were by the nature of the court and by the fact that Congress had power over all the lower courts. There don't have to be any lower courts. It could just be a Supreme Court. If you remove the Judiciary Act, there are no federal courts except the Supreme Court. And then they can only take appeals, petitions for certiorari from the state courts. And the state courts have a lot of power over their judiciaries. So you don't have to have a federal judiciary to enforce federal laws. You just say the state courts can do it. Now, I think that would be a disaster, but it's conceptually possible.
That's really interesting. And then drawing on your point of the fact that the Supreme Court has minimized power, as far as the balance of power between different branches of government goes, would packing the Supreme Court draw power away from any of the other branches of government? Or do you think that both political parties would take advantage of court packing, thereby minimizing its effects?
No, I don't. I think it would take power away from the Supreme Court, is what it would do, and it would hand it to the presidential party, especially in a time of polarization where there's very little ticket splitting. The House and the Senate and the presidency are often in the same hands. So what you'd lose is you'd lose a check on either the executive or the legislative, because they simply put their judges in. Now, no one thinks that what they all think is that they're going to retain power forever, and they'll put in 5 guys and the other side will never be able to do it again. But what you're actually, I don't think that's what would happen, but it would definitely weaken the Supreme Court. It would also weaken the Supreme Court for the same reason that Congress, one reason Congress doesn't want to expand its number is because it believes it's unwieldy. Well, it's kind of hard to have argument if we have what's called en banc panels. That means a panel of all the appellate justices, and you're there arguing a case before 11 people. It's a lot more unwieldy than arguing it before 1 guy in the district courts or 3 in the appellate courts. Well, think of a Supreme Court with 26, 27 people. They got to circulate all those opinions. They can't really meet easily for lunch or dinner. One of the things John Marshall, the greatest Supreme Court justice, did all the time is he made them all have dinner together, or didn't make them. He gave them so much wine, they all wanted to come. So they all came to John Marshall's dinners and they discussed things all the time together, all the Supreme Court. So that collegiality would, I think, diminish, which would weaken the ability of the Supreme Court to speak with a voice on important constitutional subjects.
That's a really good point. That makes sense, that the more voices you have in there, the harder it would be to get things done. Well, thank you so much for your insight into Article 3. I really appreciate you taking the time to answer some of my questions, and I believe I'm tossing it back over to Cathy.
Yes, thank you, Lindsey, and thank you, Tova. And we've got some great audience questions, but John, I want to start first with back in June, I think the Washington Post had a headline and it said something like Supreme Court goes against public opinion. And I wanted to ask your opinion on if you think that as a citizenry, we are losing our concept of what the role is of the Supreme Court and maybe even of the other branches as well. I mean, do you think there's a danger that American citizens aren't educated enough about how the Supreme Court really is supposed to make decisions? And do you think that in the mainstream media seems they may be reinforcing this with headlines like Supreme Court goes against public opinion? What's your thought on that?
Yeah, they never write that about a patent case, right? So the Supreme Court does patent decisions and all kinds of decisions. Public doesn't have a view on it, right? They do is apply the law. They look at the briefs, and it doesn't make a big stir. There are other things, search and seizure, lots of things where the public does have a view, but the public is supposed to express its considered views through its legislatures and through legislation. Supreme Court is supposed to look at that legislation. If it's constitutional, they're supposed to enforce it the way or rule upon it and allow it to work its will, whether the results are good or bad, according to the public. So I think that they should be they're supposed to be insulated from public opinion. They're not fully insulated, but the less insulated they are, the less you have any check on executive or even legislative power. So yeah, right now, certain things are unpopular, but the one I always say that was really popular, people use Dred Scott about, that slavery was required in all the states because you could bring your slave anywhere and it was property. So you could not have a free state, basically, is what Dred Scott's doing. Never mind saying that African Americans aren't citizens, did a lot of bad things. But it wasn't popular. There was a split on Dred Scott. There was a political split. That there wasn't a political split on was the Korematsu decision. Earl Warren, later Chief Justice, approved of it. He had been the governor of California when Japanese Americans were interned during World War II. Hadn't done anything wrong, but they were they had come from Japan and they were put in camps and taken out of their house and interred, meaning in the interior country, for the duration of the war. Hugely popular decision. I mean, you would get 95% of the country said, hey, that's great. And the Supreme Court said, okay, yes, he can do this in wartime. Go right ahead. Well, 50, 60, actually 70 years later, Supreme Court didn't even get asked the question, but Roberts, it was in this case, he said, this was a terrible decision. I can't believe we did it. It's really popular, though. So I don't think that popularity is a good thing. You're going to sit around and say, wait a minute, why did we have those Fourth Amendments and those Fifth Amendments and those other things about whether the government can grab you in the Constitution if we're not going to enforce them in the tough times?
Well, thank you. We have a couple of listeners who've asked about the Keep 9 Amendment. Teresa Speaks says, are you aware of the Keep 9 Amendment being proposed to amend the Constitution to codify 9 justices, therefore stopping any court packing by the legislature? And then Martha Jenkins, who's also in our audience today and has written an op-ed on it, says, in your opinion, with the Supreme Court, and I think we may have already answered this a little bit, with the Supreme Court being 9 justices for so long, would changing the size of the court now for partisan reasons make the role of the Supreme Court weaker and make it less independent? But I guess first let's talk about Keep 9, the Keep 9 Amendment. What do you think about an amendment to amend the Constitution to codify 9 justices?
I differentiate on court packing. Court packing is a partisan making more seats so you can put your guys in so that some aspect of the law that you care about right now doesn't get struck down. All right. So that's court packing. But let's say I don't know that I'm for a constitutional amendment. We've done fine so far without it, with a few bumps in the road. But I'll give you an example. Let's say that the Congress came together and instead of being mad about an outcome of a case, they said, you know what, for reasons of administrative ease, we think it was better that when there was one Supreme Court justice for every one of the appellate courts to supervise that. Like we have these emergency petitions, like some law is immediately goes into effect, like a vaccine mandate goes into effect and someone immediately asks for an injunction. One justice reviews that petition and decides whether it goes to the other justices. He's in charge of that, that appellate court. Well, if Congress decided that there should be a Supreme Court justice for each of the appellate courts, and then they said, and this shall not come into effect until the next presidency comes in, I don't know that that'd be court packing. They don't know who's going to appoint it. They're doing it for some reason that has nothing to do with the outcome of a case. It's a reform and not a court pack. What the constitutional amendment is doing now is they want to stop mischief, as the founding fathers would call it, mischief, which is doing things for the passions of the moment that don't help in the long-term way things are going. So I think 9 is a good number right now. But if people actually stood up and said, you know, we had a Supreme Court justice for every appellate court, and so that this won't be court packing, it won't be done until X years in the future, just like when the presidency, when they limited the terms to 2 terms, they said it won't apply to any president who's in office the day it comes into effect, so that it couldn't be seen as being against Harry Truman or anyone else, because it wasn't going to happen till after the politics was settled. It was just they didn't think the presidency going on forever was a good idea. And they wanted to show that it wasn't partisan. They weren't doing it just to get rid of Harry Truman or something.
So, and I remember, I think in Martha Jenkins' op-ed, she actually quotes Ruth Bader Ginsburg as saying 9 is a good number. So when you said 9 is a good number, that reminded me. And I know Justice Breyer has also really endorsed, not changing the court, at least for policy reasons.
None of them want it. I have never heard one of them say anything favorable about it. Because it became political, Justice Jackson at her confirmation didn't take any position on it. But I have a feeling, for the same reason congressmen don't want to dilute their power, and because of the collegiality I talked about, I doubt very much there's any Supreme Court justice who's wanted the Supreme Court expanded after they're there for a year.
Now, you did mention Supreme Court reforms. And Elizabeth Pinkerton, our great executive director, who is listening in the audience, has typed a question in. I guess President Biden had a presidential commission that examined the Supreme Court, and I believe it did come up with some recommendations for reforms. Do you want to talk about some of those reforms that were recommended by the Presidential Commission?
Yes, so they did talk about making it larger, and they didn't recommend that. They actually put proposals out there and said they weren't recommending anything, but they talked about a number of proposals. For instance, adding 4 when there's no majority, like when a president's appointed them who didn't have a majority and all this. And they talked about everything you hear in politics. But the one that I think they struck on that is either, depending on how you look at it, is either the most popular or the least unpopular, is term limits or age limits on justices. One of the nonpartisan criticisms of the Supreme Court is lifetime appointment, in that you have people who have been there for ages, and some of who get very old and don't retire because they're very worried about who's going to appoint them or not. And certain presidents don't get appointments at all. Jimmy Carter got no Supreme Court appointments. Now, he did appoint more appellate court justices than anyone because they expanded the size of the judiciary under his watch. So he appointed an awful lot of judges, but he didn't appoint any justices. And President Trump got 3, even though he's a one-termer. So I think that this has caused some people to look at this and say, how do we reform this so that it's not catch as catch can? And so the 2 ideas have come up. An age limit, I've heard 80. I don't have the report in front of me, but it's either 70 or 80. I mean, I think for judges, 80 is fine. They're not airline pilots, but but there's that, and there's also the 18-year limit. In 18 years, each president would get 2 appointments under this. But there's a constitutional problem with that. The current justices could not be term limited in my judgment. I think it says lifetime appointment for them, so it's lifetime. So you would have to have the new judges, you would have to say, pass a constitutional amendment saying that every justice appointed after such and such a time shall have a term limit of 18 years, period, or 18 years on the Supreme Court, and then they could, like right now, Justice Souter sits on the First Circuit. He's been retired from the Supreme Court for over a decade, but he's still on the First Circuit. And Justice Breyer's joining them there. So they still are judges. They're just not Supreme Court justices. You could do that. That a Supreme Court term should only be 18 years. There's certain people that don't like it, but it doesn't strike me that it's some kind of partisan matter. It seems. And the other one was that we should constitute the Supreme Court by having a rotating bench, that the appellate courts, you would only be, there'd be at appellate courts, and then the president, you rotate in from the appellate courts. It wouldn't be a permanent body of the same ideological blocks, is what they like to say. It would be rotating from the various circuit courts at all times. So you'd have 5 years of guys from this bench, and then they rotated. I think that's unworkable, but it is also a little less partisan. And then there's one proposal that I think is just unconstitutional all the way around. But if they change the Constitution, it's basically 5 judges appointed by one party, 5 from the other party, and then those 10 guys pick the other 5 judges. So there's 15. I don't know why that's so talked about, but it is a proposal out there.
That's really interesting. I would just be interested. We've never done this before on our Constitutional Chat show, but if our audience knows how to raise your hand, I would be really interested to see from the audience, how many of you think that we should have an age limit on Supreme Court justices? Do you know how to raise your hand and say that you would agree with an age limit for Supreme Court justices? Well, that's really interesting. Gosh, Aubrey, can you count that? We've got a lot of raised hands in favor of an age limit for Supreme Court justices. That's very interesting.
It's a young crowd, I take it.
No, I mean, well, I don't know. We've got all ages, and maybe that's the case. Maybe we do have a young crowd. But about half our audience, it looks like, maybe a little under half the audience would support an age limit for Supreme Court justices. But I was curious about how the audience came down on that.
And there were a lot of things happened. The one that's famous is William O. Douglas was really out of it at the end, and his friends Marshall and Brennan, who've been on the court with him for well over 20-25 years, had to go to him and say, look, Bill, you got to go. And so it's not just dying, it's that they sometimes lose their faculties. And both Brennan and Marshall didn't want to retire while they're Republicans, but because they knew what had happened to their friend Bill O. Douglas, they both retired. They got out because they wanted to be at the top of their game, or at least when they're still all their faculties were there. So there is a lot to be said for that, because after 80, anything can happen.
Now, on another note, Dr. Eric Braverman asks, how does the Supreme Court impact incorporated and unincorporated territories, and what mechanism is in place to add more territories? If we were going to ever add another territory to the United States.
Greenland, I think it was Greenland, right?
And Greenland.
So now this is very interesting stuff. I don't know if it goes to the topic of the day, but I find it fascinating anyway, because states obviously they all have their own constitutions, and we know what states are, and we know how they're represented. Territories, however, there was a big question under Jefferson. Did the Constitution allow him to buy territory from France, right? He buys Louisiana Purchase. They'd gotten the Northwest territories from a settlement with Great Britain after the war. And so what the Supreme Court has said is that the ability to make treaties gives the United States the ability to have territories, whoever we make, and the ability to make war. So if by war or by treaty we get territory, the United States has the constitutional power to control those territories. So what does the Supreme Court say? The Supreme Court tends to say that the territories are under congressional government. The Congress sort of rules them directly. The people there don't have a vote unless Congress does something. They have constitutional rights, but for instance, they don't have the right to elect 2 senators until they're a state. They don't have the right for a congressman until they're a state. So we have right now, let's say the Greenland Proposal. If Greenland decided they wanted to become part of the United States, they could just apply. I mean, that's what Texas did, right? Texas was its own country. It said, you know, we want to be part of the United States. They applied. That's it. They're in. I think I don't know California as well, but I know they were like the Bear Flag Republic for 9 months or something. But basically, you can just apply. But how you get to be a territory, usually by treaty. Let's say Greenland was or is under Denmark, so we'd make a treaty with Denmark. We'd say we want the territory of Greenland, and Denmark would say, "Oh, okay, we're selling," and so they'd sell, and then Greenland would be a territory, and it would be governed by Congress. And the Supreme Court has there's some very criticized cases in the Supreme Court about the nature of territories and how they're all inhabited by barbarians, basically, and so the Congress has got to run them. I don't think the Supreme Court language that they used in those cases in the 19th century would be used now, but it's precedent right now. And so the territories right now are run by Congress, but Congress mainly lets them run themselves, except for foreign policy. The Puerto Ricans have a Puerto Rican Congress and representation, and they all have a delegate to the Congress, so they can say what their problems are, even though they don't get to vote. Like Guam has that, and the Virgin Islands have that, and Puerto Rico has that.
Now, going back to number of justices, Robert McKeeman observes that if you had an even number of justices, then it would take 2 votes to overturn a lower court decision. With an odd number, then it would only take 1 justice to overturn a lower court decision. Do you have any comment on that?
Yeah, I think it would still take a majority it would still take a majority. What he's saying there is it would take a majority no matter what, but you couldn't reach a majority if you had an even number. So what you're doing there, though, is right now the rule is if the court ties, let's say the case is about Facebook, and one justice has like $1 million of Facebook stock that he didn't divest himself of. He recuses himself, so it's 4-4, and the lower courts have made a ruling. Well, if they tie 4-4, the lower court, the tie goes to the appellate court. That it gets the win. So I don't know until somebody could recuse themselves and divest themselves of the stock, you couldn't get a Supreme Court ruling on that topic. So that's another proposal in the president, that to overrule a statute, you need a supermajority, like you need 7 or 6 or something like that. That is another proposal. I don't know how it would work in practice, because the guy who got 5 votes would win the case, but the statute isn't overruled. I mean, it's hard for me to think about how that works. But no, I see where you'd have to have a larger group of people to overturn a lower court, but I don't know why that's so great. I mean, a district court's 1 guy.
Well, thank you. And Carol from Texas asks, are there lifetime appointments for other courts?
Okay, now this is interesting. So most places don't have lifetime appointments. So certain of the states have allowed lifetime appointments, I think, but almost all of them are term limited. A lot of them have like a 70-year, when you're 70, or 15 years. I mean, and some of them are elected. A lot of our state judges are elected, so they're out until they have a referendum on them, and it's an up or down thing. But lifetime appointment is in the Constitution because of the experience of the founding fathers, that the king would get rid of the judges who were doing bad, ruling against him. So that's why they wanted it. They wanted someone insulated, because there's 2 things as Supreme Court justice: you can't be fired, you can stay there as long as you're breathing, and your salary can never be reduced. So those 2 things are whatever package, whatever package you got when you got there. If it was 200,000 and healthcare, Congress can never take it away. You always get the same amount of stuff as when you got in there. They don't have to raise it, but they can't take it away. So those insulations are so the Supreme Court can't be fooled with by Congress or the president. So people think that term limits do the same thing because you're leaving at some point. Some people think that that will mean that they'll have an eye to go work for Facebook, but I think they'll be old enough that that won't be a problem. But there you have it. But there aren't too many other nations of the world that have lifetime appointments, I don't think.
That is really interesting, and it's interesting how that particular structure, and I guess so many other aspects of our what is protected by the Constitution, enshrined in the Constitution, started as grievances that were listed out in the Declaration of Independence. And that's one thing that we learned last week from Article 3 is that they in talking about some of the grievances and King George and the judges, and that's a great point. So could you go over one more time how cases make it to the Supreme Court? I think we learned last week that the Supreme Court has original jurisdiction, but then they also have appellate jurisdiction. It does seem like, I forget what the percentage is, but it's a really low percentage of what cases that aspire to make it to the Supreme Court actually make it to the Supreme Court. And how does all that work?
Well, here at NCLA, we've been in existence for 5 years, and we finally got a case accepted by the Supreme Court this year, Cochran. So that'll be argued in the fall. But obviously, we've brought a lot of cases. So original jurisdiction is like, in order so the states don't go to war against each other. If the states have a problem with, like, the one that I always love, there's two types of cases. A river changes its banks, right? And then Mississippi and Louisiana fight over who has the island, right? That sort of thing. That all goes to the Supreme Court, and the Supreme Court appoints a special master, a guy who knows about river law and knows about islands and how things are formed. And they say, go give us a report. And they give him a report, and they almost never disagree with him. So those are all things. Sometimes the states do things to each other, and that goes directly to the Supreme Court. There's no fact finding in the lower court. That is original jurisdiction of the Supreme Court. And the state has to, I think the Supreme Court has to take it. I could be wrong about that. I think they have to take those cases, original jurisdiction cases. I can't recall them never not taking one. But then there is everything else. And everything else is the Judiciary Act of 1789, as amended all these years, says certain cases the Supreme Court can't take, right? Like I told you about the immigration. If the immigration executive, administrative law judge, or in the executive makes a decision, they're not allowed to take it in certain cases. That's because Congress has said that. But other things, it goes to the district court, you bring your case, and you can only get certain cases in federal court. If you're from the same state, if you're both from Missouri and you have a contract dispute over $10,000, you can't get to federal court. There's no what's called diversity, which means if you're from different states and you sue each other, so that there's no unfairness of the state courts, you can go to federal court. Okay, so you get into federal court. Now what? You lose, you go up to the appellate courts. The appellate courts have to take your appeal. Now, they can just say affirmed or denied, but they have to take it and do something. All of our circuit courts do. But the Supreme Court, for all those cases, for the Fourth Amendment, if the police have come in and seized your stuff and they didn't have a warrant and they searched it, all that stuff, whatever the lower courts did stays unless you petition for certiorari. That means you say to the Supreme Court, we got a problem with these lower court decisions, you got to solve it. By and large, the Supreme Court says no to all of them unless there's a circuit split. If the Second Circuit over here in New York and Vermont and all that splits with Florida and Georgia and all that, and the 11th Circuit, well, then the Supreme Court says, I better solve that because I can't have one law over here and one law over here. But most of it, if it's just a bad thing, they won't take it. They won't take it unless there's a circuit split, almost always. And so the number I've heard is 1% or less of the cases that are petitioned for certiorari get taken. But some of them get this. Sometimes it's the same issue. So they take the case they like, they decide it, and then they remand your case saying, we now send this back to all these circuits with instructions to review what we just said in this case. So it's not as bad as it sounds, because what they do is sometimes they look at a problem that keeps coming, take the one case, and then remand all the others, telling the courts to follow what they just did.
Great, thank you so much. And finally, Sandy Thatcher asks, on what grounds can justices be impeached? And James Olson also asks, can Supreme Court justices be impeached?
Well, the guy who was impeached as Supreme Court justice was Samuel Chase. And Samuel Chase, I think it had to do with the creation of the Bank of the United States, I think. But a lot of people hate him. He's a acerbic guy, but it didn't work. But justices in general are impeached. They have life tenure upon good behavior. So you can be impeached for not having good behavior. High crimes and misdemeanors is what it says in the impeachment. And so what that is Congress. Now, the judges who have been impeached, and it's the same for all the judges, including the Supreme Court. A lot of them, if you take a bribe, you can be impeached real fast. It's happened to a bunch of judges. Now, I wouldn't say a bunch. We've had like maybe, I think in the last 50 years, maybe 10 to 7 judges impeached. And it's almost all bribery. Sometimes bribery and theft is what I normally think of. That's really what gets you. They're political outcomes. I mean, there used to be the bumper stickers, impeach Earl Warren, but no one ever filed impeachment against Earl Warren. There are a lot of theories of how you could impeach him, but just like court packing, you don't impeach. If you go for partisan reasons, you get partisan opposition, and people sometimes shy away from it. So I don't see an impeachment. Now there's a big attack on all these justices that they said something in their confirmation they later didn't do in a case. Well, I've watched all these confirmation hearings, at least in part, and none of them say how they're going to rule in a case. None of them. So that's true of Justice Jackson right now. It's true of Thomas back when. They never say how they're going to rule in a case. So when you see all this stuff, oh, we got to impeach him because they lied about this, that, or the other thing, none of them said how they'd rule in a case.
Well, thank you. And this has been a fascinating hour, and we so appreciate your time. I want to go back to Tova and Lindsey real quick to see if y'all have any closing comments that you might want to add.
Well, I just wanted to thank you again for being on. This was a really fascinating discussion. I loved the extra bit of audience participation, and thank you to the audience for listening so actively and adding your input. I think it's so important for all of us to really truly understand the Supreme Court because its decisions really affect our lives. So I'm glad we could have this conversation, and I hope you all have a great week.
Thanks, Tova. And Lindsey?
Absolutely. Thank you so much for your insight into Article 3. I really appreciate you taking the time to be here with us, Mr. Vecchione. And thank you all in the audience for hanging out with us. I know I really learned a lot, and it's been good to be with y'all today.
Well, thank you. And thank you both for your great questions. And we want to thank you very much, Mr. Vecchione, for being with us. And I want to encourage everybody to check out your organization, the new Civil Liberties Alliance. Is there anything that you'd like to tell us about that real quick? Or
ncla.org. You can go take a look at our cases. And I will tell you this, the stumper question here is, who else has lifetime appointments? I only know federal judges, but I wonder if there's anyone out. I'm going to go Google this after that, because I can't recall. But NCLA, we sue the government on unconstitutional actions by the administrative state. You can go look at our cases. We have videos, movies, that sort of thing. And I do a podcast, so you'll see that there too. But check it out, and I thank you all for watching.
Well, thank you. And we encourage everybody to come back next week. We're going to be on Article 4, and we're going to have Professor William Morrissey from Hillsdale. Lindsey, your school that you're returning to very soon. Professor William Morrissey is going to be on Article 4, which outlines the relationship between the various states, as well as the relationship between each state and the United States federal government. It guarantees a Republican form of government, that's Republican with a little r, Republican form of government to the states. So we hope y'all will stick with us next week as we continue our countdown to Constitution Day. And thank you so much. Have a great rest of the week, everybody.